Hello everyone. Today we'll discuss important landmark judgments. This is just part 1. We'll be coming with different parts, and this video is important for all those who will be preparing or who are preparing for any law entrance competitive exams, whether it be a clat, ALET, SLAT, MHEC, DU-LLB, etc. So now let's begin with our today's video. So the first case we're having is the landmark case Kesavananda and Bharti versus State of Kerala. So we have divided the case laws into 4 parts. We'll start with facts, issues, we'll discuss different issues and the judgments given by the judges, and then the important facts you're supposed to remember for your competitive exams, the one-liners. Okay. So now let's start with this. So what were the facts in this case? So in this, the Kesavananda and Bharti challenged the Kerala government's attempt under the Two Land Reforms Amendment Act in 1969 to acquire the lands owned by the petitioners. So now the issue was whether the parliament can amend any part of the constitution and what was the limit to that power. Now what were the judgments held? So in this, first of all, majority. So total judges were 13 judges, 13 judge bench. So majority of judge, that is in the 7:6 ratio, held that Parliament has the authority to amend any clause of the Constitution as long as amendment does not violate the basic structure of the Constitution. Hence, it led to the evolution of basic structure of the Constitution, evolution of the basic structure. Then, next thing it was held in this was preamble is a part of the Constitution and it can be amended. So, प्रियम्बल, ठीक है, प्रियम्बल क्या है, हमारे कॉन्स्टिट्यूशन का पार्ट है, इसको हम लोग अमेंड भी कर सकते हैं, बट व्हाट वी कैन नॉट अमेंड इज बेसिक स्ट्रक्चर. सो जो प्रियम्बल की बेसिक स्ट्रक्चर है, लाइक अगेन सेक्युलर, सॉवरेन, सोशलिस्ट, डेमोक्रेटिक, रिपब्लिक, ये जो 5 चीज है, वी कैन नॉट अमेंड ऑल दिस. सो व्हाट हैपेंड in the very case, it was held that preamble is not a part of the constitution. So Kesavananda and Bharti case overruled very case, and then it held that preamble is a part of the constitution. And in case of any misrepresentation, in case of any misinterpretation, what will happen? Judges will look into the preamble. Now moving forward, so what are the important facts you're supposed to remember for your exam? So the first one is, it is properly known as fundamental rights case. Second is, this case was heard by the largest ever constitutional bench of 13 judges, and this is, trust me, very important for you to remember. S.M. Sikri was the Chief Justice of India at the time of the judgment. This case led to the evolution of the basic structure. Parliament has the power to amend the provisions of the Constitution, including the fundamental rights. So our fundamental rights can be amended. Anything can be amended under the Constitution of India except the basic structure. Okay. Next, moving further, held that preamble can be amended, but yeah, basic structure cannot be amended because it is a heart and soul of the Constitution. Judicial review to be the basic structure of the Constitution. So basically it has given a right to the judges under Article 13 that in case if legislatures are making any law which is violating our fundamental right, judges can make that particular law null and void. And finally, it upheld 24th Amendment to be valid. Now, moving forward. Next we have Maneka Gandhi versus Union of India. So now, what were the facts? So in this, the Regional Passport Office, which is in New Delhi, ordered Maneka Gandhi to surrender the passport. She was not given any reason for this arbitrary and a unilateral decision of the External Affairs Minister, citing public interest. So we are having one natural justice principle which talks about odi alteram partem. So both the sides should be given equal opportunity. So now what were the issues in judgment? So issues were, are the provisions under Article 21, 14 and 19 connected to each other, or are they mutually exclusive? Second one is whether the right to go abroad is a part of the right to personal liberty under Article 21, and whether the Passport Act prescribes a procedure as required by Article 21 of the Constitution. So what is 21? 21 talks about right to personal liberty, right to life. So right to life cannot be violated until and unless there is a procedure prescribed by law, right? So again, this is not your absolute right, but there need to be some procedure prescribed by law. So now what is the judgment? So what was the judgment in this case was, first of all, Article 21 has a wide scope including many rights. So some of which are embodied under Article 19, thus giving them additional protection. Means कि Article 21 restrictive provision नहीं है, काफी broad है, and it includes a lot of things. Second, procedure जो भी आप use करोगे for violating Article 21 वो कैसा होना चाहिए? So procedure under the law for the deprivation of the life or liberty of a person must not be unfair, unreasonable और arbitrary नहीं होना चाहिए. Okay? Now moving forward, important facts which you're supposed to remember is, first of all, Article 14, 19 and 21 is a golden triangle. ठीक है? So it's a golden triangle. It's a mutually exclusive. It goes together. Second is, right to go abroad is a part to the right to personal liberty under Article 21. Third is, the procedure prescribed by law has to be fair, just and reasonable and not fanciful, oppressive or arbitrary. The last one, you're supposed to follow the natural justice principle while again violating the Article 21. So natural justice principle includes odi alteram partem, means let the other side be heard as well. So Maneka Gandhi should be given an opportunity to present her case. Now moving forward, next we have Indira Sawhney versus Union of India. This is again landmark case, very landmark case, which is related to reservation. So let's see what was the facts, issues, judgments and important facts to remember. So the facts related to this case is, in this, the Congress party, which was headed by the then Prime Minister P.V. Narasimha Rao, and the government came with a newly modified order on 25th September 1991. So now the order stated that an additional 10% reservation would be provided for the economically backward classes. So here what you are supposed to remember is, first of all, we are having Article 15 and Article 16, which provides that no discrimination should be done. But at the same time, discrimination can be done, so that should be reasonable. And the grounds are that the person needs to be socially and educationally backward, not economically, but educationally backward needs to be there, right? So economically backward classes से related इन्होंने reservation लेकर है, which was not covered in any reservation scheme, right? So this increased the reservation limit to 37%. ठीक है? So now what happened? Indira Sawhney, she was the journalist. So she saw young children, students protesting this, which prompted her to file a case against the government implementation. So what happened? Firstly, this case began with 2 judgments. Now it went to 3 judgment, then went to 5 judgment, then 7 judgment, and finally it was having 9 judge bench, and the verdict was given by in the 6:3 ratio. So now what were the different issues in this? First one was whether caste on its own constitute a different class, and whether economic criteria could by itself be the detriment of the class. Second, whether Article 16 clause 4 was an exception to Article 16 clause 1 and is exhaustive in itself of the rights of reservation. Third, thus Article 16 clause 4 allows classification of backward classes into backward classes and most backward classes, or permit classification among them based on economic or other consideration. Now the judgments were, first of all, it held that reservation, they are constitutional, they are constitutionally valid. Second, Reservation should be given on the basis of socially and educationally backward. Economic should not be the ground. Finally, it overruled the Devadasan case and held that carry forward rule is valid so long as it does not violate in a particular year and exceed 50% of vacancies. So Indira Sawhney held that, in this case it was held that 50% reservation should be there for ST, SC and OBC. इससे ज़्यादा extend नहीं होना चाहिए. And your ground should be socially and educationally backward classes. It cannot be economic backward classes. Moreover, reservation in promotion shall not be allowed. But later on, of course, amendment हुआ and reservation in promotion is also allowed now. Any new disputes regarding criteria were to be raised in Supreme Court only. So important facts to remember. First of all, this case is also known as Mandal Commission case. Upheld the carry forward rule and overruled the Devadasan case. Reservation should not exceed more than 50% in a year. Finally, there was an introduction of 103rd constitutional amendment which violated the Indira Sawhney judgment. So what 103rd amendment did was, reservation for economically weaker section of the society was allowed. 10% reservation was given for general category, again which led to 60% reservation. And in Indira Sawhney it was held that 50% ज़्यादा extend नहीं हो सकता है, right? So 60% हुआ, and right now this particular case is sub judice in the court. So let's see what will be the decision. Now moving forward, so hold that right to privacy is protected as a fundamental constitutional right under Article 21 of the Constitution of India. The judgment delivered in the case of MP Sharma and Khadak Singh was overruled in this case. Aadhaar card cannot be made compulsory for linking the bank accounts, etc. but made linking of Aadhaar and PAN card mandatory for income tax returns filing. The validity of Aadhaar was upheld by the court after striking down various clauses and sections of the Act which were contrary to the Constitution and violated the rights of the citizens. So जो भी provisions हमारे fundamental rights को violate कर रहे थे, वो सारे sections को क्या किया गया? Struck down कर दिया गया. So now what are the important facts you're supposed to remember is, first, Supreme Court declared that right to life and personal liberty guaranteed under Article 21 also implicitly includes right to privacy. Second, court held that right to privacy also includes right to be forgotten and right to be left alone, which is considered to be a fundamental right. Acknowledging the importance of privacy, the government has presented the Personal Data Protection Bill 2019 in the Parliament, which is yet to be passed. Finally, it explicitly overrules previous judgments of the Supreme Court Khadak Singh and MP Sharma case, which held that there is no fundamental right to privacy under the Indian Constitution. Also, KS Puttaswamy case overruled the decision of ADM Jabalpur versus Shivkant Shukla. So again, this is very important. ADM Jabalpur versus Shivkant Shukla के केस को भी overrule कर लिया गया था. This case is also known as habeas corpus case. Moving further, next we have Shreya Singhal versus Union of India. So now, what are the facts related to this case? So in this, first of all, what happened was two girls were arrested for expressing their displeasure at a ban called in the wake of Shiv Sena chief Bal Thackeray's death. So this woman posted their comments on the Facebook, and after that, police officer arrested them. So now, what are the issues to this? First, whether restriction on the issue of online speech and intermediary liability in India is violation of Article 19 Clause 1 Clause A. So अगर आप लोग online कुछ भी post करते हो and on basis of that if you are being arrested, so क्या ये हमारा freedom of speech and expression violate कर रहा है, which is our fundamental right? So basically section 66A empowered police to make arrest over what policemen in terms of their subjective discretion, so police के ऊपर discretion था, could constitute as offensive, menacing or for the purpose of causing annoyance, inconvenience, etc. So this judgment is again a landmark. It led to struck down section 66A of the Information Technology Act 2000 relating to restrictions on the online and free speech as unconstitutional on grounds of violating the freedom of speech guaranteed under Article 19 Clause 1A. which is not saved by Article 19 Clause 2 and 21. So 19 Clause 2 basically it provides the reasonable restriction. But यहाँ पे जो grounds mention थे ये reasonable restriction में fall नहीं करते थे Article 19 Clause 2 में. That's the reason Section 66A को struck down कर दिया गया. Right to know is a species of the right to speech and expression provided by the Article 19 Clause 1A of the Indian Constitution. Now, what are the important facts you're supposed to remember? First, Supreme Court struck down Section 66A of the IT Act, read down Section 79 of the Information Technology Act and the related rules. The court held that the public order restrictions under Article 19 Clause 2 of the Constitution would not apply to cases of advocacy but only to incitement, specifically incitement which has a proximate relation to public disorder. So advocacy means if you're just presenting your viewpoint. So अगर आप अपना viewpoint आगे रख रहे हो, so you will not be arrested. But if this is leading to public disorder, then of course this will be in violation. So recently Supreme Court has ordered not to arrest anyone under Section 66A of the IT Act. So this is all. We will be coming with our next video soon. So thank you everyone. Stay tuned for our next video.